Number two, I'm wondering if you can help describe in more detail exactly what we're looking at. Sounds to me this has something to do with the criminal records of prospective or current tenants and the ability of housing providers to consider those criminal records. Am I correct about that? Maybe you can fill me in a little bit more.
Yes. So this concept will address, it prohibits housing providers from considering a prospective tenant's criminal conviction, but after certain time periods.
Are those time periods specified? Do we know what they will be, Madam Chairman?
In the concept that we're reviewing, I believe that we discussed for 3 years after a felony charge and 7 years after a misdemeanor. I'm sorry, flipped. Yes.
Yeah, I was going to say that didn't. That would make more sense.
Yes, I'm sorry.
So 7 years after a felony and 3
Yes.
years after a
Yeah.
misdemeanor. And are there any current statutes or laws that prohibit the review of criminal records by housing providers for prospective tenants?
Jonathan, can you answer? Do we have anything in the current?
I don't believe that there's anything in the landlord-tenant sections of the general statutes that would prohibit that sort of look back. There might be some interaction with some laws that were passed in the previous sessions about prior criminal convictions generally, but they do not specifically apply to landlords and tenants.
Does that answer your question, Senator Sampson?
Yeah, I had a little difficulty hearing, but I think I got it. That there's nothing really there. I guess I have one final question, and that is, how does this relate to erased records under the clean slate provisions that were passed in the legislature over the past few years?
Can you ask that question again? You're asking how it relates to the one we passed.
Yeah, clean slate, which is a policy that passed, I think, 2 years ago.
Yep.
It may have been multiple bills, but effectively that is a state law that effectively erases criminal records, and the timeframes I think are similar to what you just described for this bill. I'm just curious whether or not in a record that is erased, but there may still be some other public record of it, newspaper article, something like that, whether that would still be prohibited to the landlord. I don't mean to dig too much into this.
Yeah, no, that's okay. I think,
but I am curious to know how it relates to clean slate.
Yeah, I'm going to see if Jonathan can answer. I have my answer, but I'm going to see if.
I believe under the language for this bill that's been discussed, any conviction that has been erased through any other operation of law could not be considered by a landlord in making a decision concerning a tenant's application.
Okay, are there any other questions?
Yes, ma'am. I'm just waiting for you to recognize me. That's all.
Yes.
When he answers, you should turn it back to me.
Okay.
I'll just make a couple of comments on this, which I don't know how to describe it politely. I think it's madness to suggest that landlords should be restricted from certain information from determining whether or not they've got a suitable tenant. Certainly, a landlord is going to be concerned about whether someone is going to be a viable tenant from a standpoint of, paying the rent. Do they have an income? Where does it come from? Do they make enough money? How is their credit situation? Certainly, landlord's going to be concerned about, the maintenance of the property and what the prior history of this proposed or prospective tenant is. But I think that the criminal record and activity of a prospective tenant may be even more important than those two other items. Landlords, have an obligation not only to protect themselves, but also their other tenants. I mean, if you're talking about a multi-unit property, and landlords will be restricted from being able to provide or to review the criminal records of prospective tenants. They may be putting someone who has a propensity for violent crime next to a victim in their same building. And I don't know how we've gone so far down this road. I think the state of Connecticut has drifted immeasurably on how we deal with crime and punishment in this state. And I think the evidence is everywhere. And I know my constituents are frustrated. Many people contact me telling me that they don't feel safe, going to a gas station or even, walking up to an ATM. And this is only going to make that situation worse, because now you're going to have all types of residents, whether they're renters or they're property owners, that are living side by side with tenants with no reassurance that they're not living next to someone who has committed a rape or sexual assault or a violent crime with a firearm. And these are real concerns that are going to affect the lives of people in the world. I understand we want to make an effort to try and get people that have committed crimes back into our society, and I'd like to work on that also. But taking tools away from a property provider that are necessary for them to protect their own property, their own liability, and the lives and safety of the other residents and people that live in that community is a very, very bad idea. I'll be voting no on this today, and I'd like a roll call vote, Madam Chairman.
Thank you. Any other?
To drag out this conversation, I just want to say that I heard my colleagues loud and clear. And I certainly understand and respect where they're coming from, certainly when it comes to people that have indeed paid their debt to society and want to find a way back to, being good citizens and should be accepted as such. I just don't know that this is the way to do it. I'll stand by my comments earlier about the potential danger of putting people with a criminal background next to potential innocent folks. The danger there. Not everyone who has served a sentence for a crime or been convicted of a misdemeanor is a bad person, obviously. I mean, many of them are reformed. I just want to state for the record, there's nothing stopping a housing provider from accepting someone with a criminal record now. It happens every day. And I think that it's just something that the landlord will do in their review of the entire package of information, the person's job and income and credit and criminal background history are all factors in determining, who's a suitable tenant. And I just think taking tools away from a property owner is a very bad idea. And maybe the most key point that was made in this whole conversation is the one made by my colleague, Representative Weir, which is that, in America, people have property rights. Property is owned by the property provider, the landlord, what have you. It's up to them how it's used, and ultimately they should make the decision about who they have as a tenant. And I find any restrictions on their ability to make those determinations to be flawed. I also think that these are private contracts, which I've said many, many times, between the parties, and they should be able to negotiate the terms. And someone that is, maybe lacking in the credit department might be able to, if there weren't laws prohibiting it, pay additional or advanced rent payments to get access. Maybe someone with a criminal record could do something else to make them more attractive as a prospective tenant to make up for anything that's perceived as a negative. Also, we by passing laws like this, we're preventing people from being able to truly negotiate the terms and make a case for themselves going forward. And then the final thing I will say is two things. One, I'm very hopeful that when we have a public hearing on this, that we do hear from folks that were tenant applicants that were turned away. so we can hear their story. Because I doubt sincerely that there is someone that is appears reformed. They have a job and they are on the right track. That they're being turned down for a rental. I find that unlikely. So I'd be curious to see how many folks like that show up for our hearing. And then the last thing, which is I would like to very much discourage in the drafting of this bill, Madam Chairman, the inclusion of CHRO. I think that we have housing court. And when you're talking about the potential of tying things up in a non-court final process, maybe to the detriment of both parties, and certainly to the housing provider, which might lose the ability to rent their property for some period of time or something like that. I see that as a big negative. So I would remove the CHRO part in the drafting. It's just my 2 cents. And I'll leave it there. Thank you again.